Not on mute. Good morning, happy Saturday, happy July. This is Latavia, your legacy counselor, and welcome to the July installment of Legacy Conversations. I did admit I missed June, but I'm back. And just as a reminder, if it's been a while, or if this is your first time tuning in, Legacy Conversations is a series I began to do just that, to have a conversation. Over the course of my career, I've kind of gone back and forth in terms of practicing estate planning or various aspects of real estate. And the more that I learn, the more that I see, the more important this conversation becomes to me personally and for people that I know and just people in general, because there are so many things that go on that we don't think about and they're kind of overlapping. So, all that to say, this series was started to be able to get the conversation started, to kind of break or demystify some things, challenge some myths, misconceptions that people have around estate planning, of just what it is, why we need it, what it looks like for you, helping you to understand that you have a right to do it. It's not just something for wealthy people, all of those different things. And so we talk about what is estate planning? What are the components of an estate plan, or as I like to call it, legacy planning? So there's a will, you have power of attorney, advanced medical directive. There are trusts, or is it a trust is a tool that can be used. There are various types of trust. But today, and in the previous series sessions, I have talked about all of those things in some way, shape, or fashion, and we will continue that conversation. But a conversation I was having with a friend a couple weeks ago really got me to thinking in terms of what today's topic. So some of it is going to focus on part of the planning process, but I also want to spend some time emphasizing things to take into account after someone passes, whether that's yourself or the person, a family member who passes, in terms of making sure that you're thinking your plan is taking all of those things into account. So the conversation I had with my friend a couple weeks ago was around relationships, marriage, divorce, and just how a lot of my friends and I, we're not spring chickens anymore. We're not old, but we are more mature. We're older. We have been working. We are a bit more established in life and in our careers. And as she was talking about in terms of when she's dating or just thinking about when the time comes for her to get married, whether or not a prenup is something that I would recommend. And so for me personally, I don't personally want to use one or recommend people use one from a standpoint of my beliefs, in terms of believe if the Lord brought us together and if we're getting married, we're doing this with the intention of being together. And I don't want to go into it planning for the end. However, the logical or the attorney and the logical part and the attorney in me definitely understands the concept of them, and that it is a contract and you're entering into an agreement. Also knowing that a prenuptial agreement is, despite the I think maybe kind of the common reputation it has about it, a prenuptial agreement is essentially, it's a contract we are entering into, or an agreement we are entering into before we get married. So that could be as simple as we agree that we are coming together, and in the event that this relationship dissolves, we're going to put some conditions on, this is how we plan to dissolve the marriage. The ones we hear more about is like, oh, the prenup says if you come, essentially, if this ends, you leave with what you came in with. Or there's some that have clauses that, hey, if the marriage lasts 5 years, one spouse gets X percentage, and then so long, kind of like a graduated scale. There are others that it could say, hey, uh, we come into this marriage, there's no children, but hey, if we end up having children, then we are agreeing that we are both going, this is how we're going to handle custody. This is what child support could be. So there are a variety of ways that it can be approached. And so we talked about that a little bit, but the bigger part of it is that I was talking about with her, and I think it applies to a lot of people, is if you are thinking about a prenup, or even just a relation, marriage or not, if you are someone that you know that you are going to inherit property, or there's a good chance that you're going to inherit property, those are things that you would also want to consider if you're talking about a prenuptial agreement or even a postnuptial agreement, because postnuptials is essentially sometimes people will enter into it after they get married. They decide, oh, hey, we need to go ahead and figure some things out. We want to enter an agreement. Or people could do it right before the marriage is dissolving. But in this case, she's someone who she is knows she's going to inherit real property or a house from some family members. And so it's a matter of, okay, hey, how is that person planning to leave that property to you? If it is a matter of where the person, let's say it's your mom has owns property and they have a will where they're listing you as a beneficiary, or for the house to go to you when you pass away. When they pass away and that ownership is transferred to you, you own that house outright. And then if you inherit it before you get married, then it's yours. Or even if you inherit it after, depending on the state you live in, those generally gifts or inheritance are not deemed to be marital property automatically. You would have to do something. So let's say, for example, you're going to say mom is A, leaves property to B, or let me say Alicia leaves property to Betty. Betty now owns it and Betty's married. Betty gets it titled in her name only, but then let's say she and her husband start living in the house together. And at some point, she decides she wants to convey owner, transfer ownership from herself to herself and her husband. When she does that, it now becomes marital property, or becomes they both become owners. So anything that happens from that with that house from there, both of them have a say in it. Whereas if she just kept it as her entitled in her own name and it was something she inherited, then that continues to be her property. And let's say maybe she rents it out or something of that nature. So that's one example of where if you are thinking about kind of what how to talk about how to have that conversation with a significant other as you are preparing to get married, or even if you already are married, those are things to think about of, um, am I going to inherit property now or in the future? Have I do I already own property that was inherited? And the other thing too is, in terms of when we talk about the estate planning piece, well, a will is great in terms of putting out the instructions for what you want to have to make sure things go to the people and to the places that you want it to go to, as opposed to defaulting to what the state says. Another option or tool is a trust. And a trust, the most simplest way I can explain what a trust is it is a bucket, or it is a separate pot that you are putting property in. You're putting assets in. I use the analogy of bucket. So at bucket A, I'm putting my property into the Latavia Trust. So now I don't own it personally, but my trust owns it. And so when there's a situation specifically with property where there are several children or people who stand to inherit the property, sometimes, or you want to make sure that that property stays in the family or in the bloodline, you want to prevent it from being to where it ends up in the hands of non-family members. That is where having a trust or putting property in a trust, whether it be finances in terms of funds in a bank account or investment account or actual real property, if you put it, you transfer ownership of it to a trust, then the trust owns it, and a trustee is appointed in terms of the person who's responsible for carrying that bucket, making sure everything in that bucket stays safe or grows. And it's not a matter of you have multiple people owning it. An example of this, I helped someone recently. Their mother, they now have guardianship of their mother's properties just for health reasons. And the mom owns property. And mom is currently in a position to be able to live there, take care of it. But we were having a conversation around, okay, hey, the person I'm speaking to, she has four, there's five of them total. She has four siblings. So it's a matter of, okay, right now mom owns it, But when she passes, she wants it to go to all of the children. Nothing wrong with that. The challenge is, as I was talking to the person, is she knows for a fact that at least two of her siblings would want to just sell the property. One would want to live there, but is not necessarily in a position to take care of the house. And so we were talking about, hey, these are some things to start having these conversations and consider, because right now, even if the mom has, if you create she creates a will, that's great. It specifies what's going on, or if she only wanted it to go to two or three children as opposed to all five. But there's still the thing to consider of, once that house passes to to the children, whether it's three or five, now there are five owners of this property. And if the five siblings are all on one accord and they are in agreement that, hey, we're going to keep the house, we're going to use it, maybe one person's going to live in it, but everybody contributes to the upkeep and maintenance of the home, or hey, we're going to rent it out, or whatever the decision is, that's great. But it really is going to depend on, is everyone in agreement and on one accord? Because what often happens is you'll have two or three that are like, hey, I don't, either they don't live in the city or the state where the house is located, they're not interested in it, they have their own property and family that mean they're responsible for, and so they're not interested. And so they're like, hey, I want to sell. But the other two don't want to sell. And then where it becomes tricky, or sometimes where where you come into the issue of how houses sometimes get in the middle of disputes or get taken from the family, is if you have, let's say there are four siblings, or in this case there's five, but let's say four of them want to sell or are thinking about selling, or even three want to sell and the other two are not in agreement. But let's say the three decide, oh, well, we're just going to sell our interest in the property to this third party investor. Now the two siblings own the property with this investor who has essentially majority ownership interest in this property. And if they decide, well, you know what, I don't want this, I want to do something else with this property, I want to be able to flip it, or depending on where it's located, like if it's land, I want to do some other things that these my co-owners are not interested, they could potentially file a lawsuit, asking the court require that the house be, that they kind of, for a quiet title, or for essentially for ownership, to kind of compelling the other owners to transfer their ownership to them, or that the property be sold. And it just becomes ugly in this whole thing, which all of that could have been avoided if there had been conversations ahead of time about what was the desired outcome for the house, and making sure that everyone was in agreement before the house ownership was transferred, or the house being placed in a trust, and instructions being put in place for what was to be done with the house, um, setting up an account for how to pay for it if there's a mortgage on it, making sure there's funds in place to cover the mortgage. Um, so that's, like I said, that's kind of an example of how things can go wrong when we're talking about property. An example of one where I guess just an example of how things could look if you created a trust, when putting the property in there, there's clauses that can be put into the trust agreement that specifies that, hey, any beneficiary, any property that, or beneficiary of this trust, those proceeds are shielded, or are separate from marital claims. So anything, like I say, if I were to inherit something from a trust, it's saying that only my linear descendants, or lineal descendants, are able to make a claim to this. If my spouse cannot access it, cannot make a claim for it. It's not subject to, it cannot be considered to be marital property. Um, and so, like I said, that's just one of the things that like I said, my friend and I were having the conversation about marriage and prenup, and it's like, oh, well, because with what I said to her and what I say to anyone that I'm working with is always, well, what is the reason for doing it? If you're considering a prenup or any type of agreement that you're going into, why are you doing it? What are you looking to protect? Specifically with respect to a prenup, it's what are you looking to protect from essentially what are you looking to protect from the hands of this significant other or potential spouse in the event that things, dissolve or and don't go well? Because if it's hey, I just want to make sure they can't take half of everything, well, that's not automatically going to be the case depending on where you were in life when you all got married, what you own, what you have versus what they have. It's not always cut and dry that way. I think all the times we think about, we hear people say, and typically it's a wealthy man and their wife, like, oh, if they get divorced, she gets half. And that is the case sometimes, but that also, with that, you have to look at, well, how long were they married? What was the financial situation or status when they got married versus now? And most of the times in that case, it's been 20 plus years that they've been married. And generally, in those situations, the one spouse who is wealthy has accumulated that wealth or grown that business over the course of the relationship. So there is a very strong argument that the spouse contributed to that growth. Even if they did not necessarily go and work every single day, they made it possible for that other one to be able to do that. And so that's one of the things that are looked at in terms of why a spouse is entitled to have. But if it's more of, I just like I was talking about before, of I want to make sure that there's, if it's property or even funds that I know are coming to me or have already been distributed to me, that I want to make sure remain in my family and my husband or future children are not able to gain access. Another example of where this has happened, I've seen where this happens is, let's say you have a parent who passes away, property is left to four children, um, and it happens to be four boys. They're all married. Three of the sons pass away. They had wills or didn't have wills, so their ownership interest in the property passes to their spouses. Now you have a situation where there's a house that's owned by one son and essentially three women who were not related, and they have majority ownership and now essentially can have a bit more of a say so in what happens with this house, because it is their house. No one did anything wrong. It's just kind of the nature, kind of, as they say, the way the cookie crumbles. And so that is where I would say I am a proponent and encourage people to look at a trust, whether it is like I said, there are different types of trust, that you if it's life insurance proceeds, if you know that you have a sizable retirement account and you want to make sure that your loved ones are taken care of and that the money is distributed in a way that is going to be a benefit to them, but also not entice them to just kind of blow the money. Um, the trust is a very great tool to do those things, to where I like to say it gives you a little bit more control of your things even after you've passed away. But it's also a helpful tool to have in place while you are alive, because let's say you create the trust. Um, well, I'll use myself. I've created the Latavia Trust, and then I put my property in there. So I myself do not own it. The trust owns the property, but then I open an account, a trust account that I'm putting funds in to grow. So that way, in the event that, excuse me, something happens to me where I'm not able to work for an extended period of time, I've put funds aside and established who I want to be kind of a substitute or designated trustee to manage the funds and manage to make sure that the trust is in a position to cover my expenses while I'm not able to work, or in the event that there is something like long-term medical need, that I've already put things in place so that the trust can cover it. while I'm so it can help take care of me or manage things while I'm still alive, and then also have things in place for once I pass away. If I want to make sure that my daughter's taken care of in the event that something happens to me, where, like I said, where I'm still alive, but I'm just not able to take care of her the same way, whether it be financially or just from a standpoint of being physically present. I designate a guardian or someone who I want to do that for her in my place, setting aside a pot of money that said, hey, this is to make sure that she is able to be taking, health, education, maintenance, those things, even when she's still a minor. Or, hey, this pot of money is set aside for once she reaches a certain age, then it can be distributed to her for her to do with it as she pleases. Or this money is to be provided to pay for education, whether it be college, trade school, whatever she may decide. I'm setting this money in this over here, so that she can do that. So, one of the beauties of a trust is you can create the trust, and then there can be kind of sub trust to where, hey, I'm creating this trust, but when I pass, I want you to take, let's say, if I had multiple children, so I have a trust, I've created this account, there's money or there's assets in the trust. And so when I pass away, I'm instructing my uh, successor trustee or person who will become the trustee after I pass away. I'm instructing them to know, okay, I need you to create three other trusts, one for each of my children, or in my case, one for my child, one for my godchild, and my niece. Um, Create trusts for them and then essentially do equal distributions to all of those trusts, so that, and then manage them and make sure that if when I pass they're still minors, okay, make sure if it's in this investment account, make sure you work, either you the trustee or you work with a financial advisor to make sure that these funds at bare minimum stay where they are, but realistically I want you to make sure that they're growing, so there's actually something for them to inherit. There's a benefit. There is a dollar amount that can be distributed to them at the designated age, or if they are in school and they need money for books or for housing, that's access there. Or if they decide, hey, after I graduate, maybe they got a scholarship. I don't need the money, but I want to be able to start a business. Now this money is set aside there. It's really what you want it to be. But I put a big disclaimer caveat on all of this. As great as I think trusts are, they are only as great or as beneficial as you allow them to be. Because what I have seen a lot of is people will create a trust, but they don't fully understand what they've created or how it works, or they don't actually fund the trust. So you can take the time, and there are a lot of templates and DIY things, and I'm not against that. I understand everything costs more these days, and attorneys are expensive, or just the process takes a while. And so you'd rather just go somewhere and do it and write it down. And I'm not completely knocking that, but if you're going to do it, make sure you understand what you're doing, what it is, and then also how to actually fund your trust. And when I say fund your trust, that means actually, if we go back to the bucket example, if you create, let's say you get the trust, you create it, you now have this bucket, but you need to actually go and put things in it. And the way that works with the trust, with if we're talking about property, you need to then do a deed transfer, change the ownership of the property from, so if it's owned by Latavia, I need to now convey that via a deed to, say, from Latavia grantor conveys ownership to the Latavia Alexander Trust, XYZ. And there are ways you can do that on your own. You could work with the title company, you could work with an attorney, but that's one. So, and then that's with property. If it is, let's say you want to list your trust as a beneficiary of your life insurance policy, you need to contact the holder of your policy and ask them, okay, what is the specific language? How specific, what do you specifically need me? How do you need me to list the trust as a beneficiary to make sure that the trust can be a beneficiary. So that way the money is not going into the trust right away, but when you pass away, instead of it being an individual listed as a beneficiary, you have listed your trust as a beneficiary. So the life insurance company will pay those proceeds into that that account that's opened in the trust name. So you also need to open a bank account with entitled in the trust. And if you tell the banks, hey, I want to open a trust account, they know what you mean. They will get it set up for you. And then if you wanted to make monthly deposits or quarterly deposits, whatever your budget allows, you can start putting money into the trust so that the trust has assets, whether it is to one of the things that comes, or a question I get of if someone sets up a trust, and okay, well, once I pass, who is responsible or who's going to, how are the taxes going to be paid on a house or the lawn, getting the grass cut, getting those different types of minor, sometimes major repairs. Are my children or my family members going to have to come out of pocket for that? And it's like they could, but ideally you're going to put aside money. You're going to be working on that to where the trust account is building so that it has money and it will continue to grow so that the property can be maintained. Because if the trust runs out of money, then eventually it's going to need to be dissolved, or someone is going to have to come in and either buy, or if you still end up losing the house. So like I said, it's a great tool, but as with any other tools, you need to make sure you know what tool you have, how you use it so that it is the most effective. Like for example, I just got this Apple Watch. I know the basics, but I have not taken the time to fully look at in terms of what all it can do, how to do it. So I know I'm not getting the full benefit of this watch because I'm only using a fraction of it. And so I would say keep that in mind, whether it be, and I know that this has been a very general discussion, but it's general in that there's a lot of different avenues when we talk about estate planning and different agreements, but it's not one size fits all. And so, like I said at the beginning, the goal of this is to just, I want to be able to give you some things to help you start the conversation for yourself. I always say, have that conversation with yourself. What are your goals? What are your desires? So that you can in turn start having that conversation with friends and family to think through it. Because the more we talk about, the more comfortable we get talking about it. And then my goal and my prayer is that these conversations will then lead to action, and you will start um, taking steps and taking action to create and implement a plan for yourself, having conversations with your parents, with your grandparents, aunts, uncles, are like, hey, well, do you have a plan, or what are you thinking? And that's where people, whether you own property or not, I want to reiterate, if you are alive, you have a need for a plan. I don't want, I know oftentimes, and I'm guilty of it myself, where it's like, I don't have enough to do this. If you are alive, there is a reason you have something to plan for, even if it is just a matter of specifying, if I get sick, if I end up in the hospital, what do you want to be done? Who do you want to be the person making these decisions for you? Whether it be healthcare decisions or things from finances. Who do you want to be the person making those decisions? Don't just assume that oh, it'll be fine, or it'll be, well, my mom will do this, or my spouse. But then what if they're not in agreement, or if it's only your children? Also, if you have minor children, or if you have children who have special needs, or even adult children who have special needs or who may have a disability that you are taking care of, what's going to happen to them? Who do you want to take care of them? And not just, I would say, if you think of Cinderella, not just make sure they have a roof over their head, but who is going to take care of them as close as possible to how you would do it, or in the way that you would like them to be raised or cared for. Like, obviously, there's no one is going to love my daughter or care for her the way that I and her father do. But if something were to happen to us, we want to make sure that there's someone or a group of people who are in place to take care of her mentally, spiritually, emotionally, financially, as close as close to or as similar in line with our beliefs and how we would want her to be raised. And so those are the things to think about. And I know that it's a lot. It's a Saturday morning, but like I said, the goal here is just to help you, give you some things to think about and to help get the conversation started. Within my firm, I do estate planning, so I would be happy to schedule a discovery call with you to just kind of talk about where you are, what are you thinking about, and then to make a recommendation in terms of what would be the best course of action for you. Or if you're ready to go ahead and start your planning journey today, you can schedule a consultation. The website is lalegalsolutions.com, and that's solutions with a Z at the end. Estate planning, I have on the website, there's information about the estate planning packages that I offer. If it's a will-based plan, those start at 1,200. If it is a trust-based plan, those are starting at 3,250. But the information is there in terms of what is included in those plans, in those packages. And I guarantee you, I will be with you every step of the way. One thing that I also include in my plans is that it's not just creating the documents. There is a 3-year review included in that. So after 3 years, I'll reach out, we'll review it to determine, hey, is what we put in the plan still relevant? Have there been any major life changes that you need to adjust? And if so, we will make those adjustments, and that'll be at no additional charge for minor adjustments. One other thing that I offer for individuals, primarily for business owners, if you do not have some of the foundational contracts that you need for your business, I now have some contract templates that I and my team have drafted that are available for purchase to you, also available on the website. So there is a independent contractor agreement, there is a master service agreement, as well as a social media release, an operating agreement template, and there are more templates coming soon. But I want to thank you all again for listening, for joining this conversation with me. Let me know if you have any questions, if there are areas or specific topics you'd like me to address in future sessions. Put it in the comments, send me a message, let me know. But until next time, you all have a great day.